All right, good morning. March 2nd, another wonderful Monday. Well, here's our topic, if everyone's ready for it. It's what sellers know matters with regards to seller disclosure. What does a seller know for a seller disclosure? And the first question I'd say is, Don, what do sellers normally know with it when they're trying to fill out a seller's disclosure besides next to nothing?
Well, I think that they know the address. Let's start with that one.
Yeah.
Um, I was actually named in a lawsuit once because I filled in the address. That's all. And I learned my lesson there. That was a $2,500 lesson. So when we are working with sellers, we can't touch that thing. We just can't touch it. Nowadays with dot loop, we can fill in the address because it's not in our handwriting, but you have to be really, really careful. You cannot guide them, coach them. Um, you have to be really careful about getting involved in that seller's disclosure form.
Well, let's get into what the core principle of disclosure really is. I mean, disclosure is all about protection, not a liability, but protection. And disclosure is the single most powerful legal protection available to a seller and a real estate agent and brokerages. In ensuring proper disclosure, one, it reduces legal liabilities, prevents fraud and misrepresentation claims. Proper disclosure really helps preserve the trust between the parties. How many times has someone looked at a seller's disclosure and you're like, wow, that doesn't match anything about what I've just found. And now you're wondering, okay, what else are they hiding? How does someone say unknown about something? You either know it or you don't. But there's always unknowns, right? When things aren't truly disclosed, it leads to a trust problem. Proper disclosure also prevents post-closing disputes and litigation. And most real estate lawsuits do not occur because defects exist. I mean, they really occur because the defects were known and not disclosed, right? And those sellers who truly disclose are really going to benefit from not having to pay substantial fines when it comes to litigation. Sellers who conceal known defects, that's where the true problem is going to lie. Now, let's do a quick legal background on a legal foundation of Michigan Sellers Disclosure Act. And the Michigan law requires sellers to disclose the condition of the property and information known to the seller. Not something that they hear, not hearsay, but what's truly known. And the key legal phrase is known to the seller. So this is really a knowledge-based disclosure law of what the seller knows on the current condition of the property. Now, what the law does not require sellers to do. So this is where we start getting into concepts of what the law doesn't require. The Sellers Disclosure Act does not require sellers to conduct independent investigations. It doesn't require them to hire an inspector or an expert. It doesn't require them to verify third-party opinions. It doesn't require that they guarantee the property condition. And it doesn't guarantee that they disclose conditions that they do not know. Again, disclosure is based on the seller's knowledge, but there's also distinctions about the knowledge that that seller knows. So, what does that mean? Well, there's a critical legal distinction between firsthand knowledge and newly acquired knowledge. Ah, newly acquired knowledge. So, this is going to be the key. So, let's start with firsthand knowledge. This is very basic core. If you live in a home, I would hope that your client would know the condition of their property. We hope, right? It's firsthand knowledge. They're not an ostrich with their head stuck in the sand. Hopefully, you look around and you say, okay, hey, yeah, I know my roof leaks. Great. Why? Because they can see the hole. They can see the water and moisture. They know that their basement flooded. I don't know of many homes that have that have never had some type of water penetration into it. But guess what? It was only 15, 20 years ago. It happened one time, so I'm not going to disclose it. Well, no, you have to disclose it. It's firsthand knowledge. It happened to them. No matter how big or small it is, disclose it. Let's say a seller repaired a foundation crack. It's firsthand knowledge. It must be disclosed. Now that we have that done, now let's talk about the gray area, because this is where always we have the lawsuits come. What's the gray area? Well, newly acquired knowledge, including inspection reports. This is the biggest question that we get all the time. Oh, what the heck do I do with this inspection report? Well, let's talk about it. This is called acquired knowledge. And a buyer inspection report is initially coming from a third-party professional opinion. However, once this inspection report is provided to the seller now has potentially an actual notice of alleged defects. The seller may now have an awareness of a potential material condition or conditions, and they may now have knowledge that defects may exist. So this now becomes newly acquired knowledge to the seller, which is kind of a dangerous area for the seller to be in anytime they get an inspection report. Now, the seller is not required to agree with the inspector, but also can't ignore the information now that they have it in their hand. This is why a lot of times we say, don't share the inspection report, because the seller may now have to act on it. So here's what ends up happening with this newly acquired knowledge. So there's some Michigan case law, and it stems around silent fraud and failure to disclose. So the Michigan courts have consistently impose liability when sellers know of a defect or receive credible information. Now, okay, I'm not an attorney, but when we talk about credible information, now we'd have to define that in the courts. But the Michigan courts will impose liability when sellers fail to disclose when a buyer suffers damages or the buyer relies on non-disclosure. Maybe the seller didn't disclose things properly. But understand that the courts can impose penalties on a seller for silent fraud, fraud by omission, or misrepresentation. And there are multiple court cases where the courts focus on whether the seller knew or had reason to know. Inspection reports frequently create that knowledge where a seller had the ability or reason to know because of that inspection report. Now, inspection reports often create disclosure obligations. Now, understand there is no statute that explicitly says sellers must update disclosure based on inspection report. There is no statute that requires a seller to update it. Here's the gray area. However, once seller receives the inspection report, seller now has knowledge of alleged defects. And failure to disclose creates significant legal exposure under fraud law, silent fraud doctrine, misrepresentation law, civil liability law, and licensing law for agents. I mean, you start reading this and your head explodes. How many darn laws do we need to cover fraud, misrepresentation? A ton. And I'm sure I could find more, but I didn't want to because I thought that was enough. But I'm sure there's more that they could find. Now, the failure to disclose, when it creates these legal exposure problems, this practical legal standard is used by courts and E&O insurers. All these types of fraud, silent fraud, misrepresentation, civil. So what do you tell your seller? Well, first of all, sellers are not required to do the following after they receive that inspection report. They are not required, they don't have to agree with the inspection conclusions. They don't have to guarantee that the inspector was accurate. They don't have to perform conduct destructive testing. That's a new term I learned today. Conduct destructive testing. It's really means that the seller does not need to perform testing that requires damaging, removing, or altering part of the property in order to investigate a suspected defect. I guess this is a technical term that they commonly use in construction, uh, insurance claims, and litigation. And what sellers are not required to do after receiving an inspection report, they don't need to hire engineers or experts. However, sellers cannot ignore known information. So again, we're coming back to once it's known is the problem. So here's some best practices in legal risk management standards. Is one, if a seller receives an inspection identifying defects, the seller should probably update their disclosure or add clarifying disclosure language, which is probably what I'd recommend. For example, you might update something on a seller's disclosure that says prior buyer inspection report indicated possible roof leak. Seller has not independently verified this condition. So this protects the seller without admitting a technical conclusion that they're not aware of by firsthand knowledge. They're only aware of it because they received an inspection report. Does that make sense? Which is what's called newly acquired knowledge, which is the danger of getting these types of reports.
I don't like it.
No one does.
I don't like it because an inspector is a jack of all trades, master of nothing. So now we have someone who is not a pro. They are
Sounds
not
like
a
you just
plumber.
described me.
But I honestly don't like it. I'll be honest. I'll say to my clients, if they find mold in the attic, I'll give you that as an example. I would say to them, okay, guys, you can do something with this or you can't, but it's a brick wall you're going to hit over and over again. Like every inspector is going to find mold in the attic. They're going to find the leaky roof. Isn't that their responsibility and the reason they're getting the inspection? That's all I'm saying. I don't like it.
Yeah, so it's the newly found information. It's a terrible position to be in, and this is why a lot of agents or seller listing agents will not ask for the copy of that inspection report, or if they're asking for certain repairs, they only want those portions of that report cited. Now,
I think that one of the
it's in,
key things that you mentioned is the word credible. If a buyer has their uncle come in who is not even a jack of all trades, just someone who has an opinion, does that carry any weight in terms of the seller needing to disclose whatever information they might find or whatever opinion they might reach based on that inspection? And the answer is, I don't know. It depends on what it is.
well, the good thing is there's one great concept here that we can take away is that sellers who over disclose are rarely sued. So disclosure is not bad. And most people will probably be, well, hey, at least thank you for being honest. In today's markets, it seems like everyone's trying to hide something. And this is where there's so much mistrust in a contract starting through inspections. And when something is so obvious and it's not disclosed, and then all of a sudden that's your first red flag, and now you're starting to be suspect of the seller. So
Really good example, Eric. And here's a
yeah,
situation I have going on right now. Got a condo listed. We have an offer on it. But when we first listed it, they explained that there was a leak, which was happened because of a faucet that was leaking on the outside of the condo building. And it damaged the inside, did some created water damage. And they said, well, we fixed that and we got it all taken care of. And that was like 5 years ago. Do we have to disclose it? And the answer is yes. Yes, you need to disclose it. You need to write a little note, attach it to your disclosure form. They did that, and as you say, Eric, it created a feeling of trust on the part of the buyer that they were being forthright. As our attorney, Mr. Druki, often says, it's better to disclose than get deposed, and that's absolutely true. As we progressed in this process, we had inspections done, and they found an ice dam and leakage on the three-season porch. They also found electrical circuits were being double tapped. So now we have a couple more pieces of new information, right? Do we have to disclose those things if this deal happens to fall apart? I don't think it will. We've made concessions and so on. But if it does, do we have to disclose it? And the answer is absolutely in this case. This is not just an opinion. There is really solid proof that this happened. So,
Yeah, so you're referring to what's known as high risk scenarios. And this is where potentially let's say a prior transaction falls through due to inspection findings. Let's say if this client had terminated because of the inspection findings and they made you aware, this is one of the typically scenarios of highest liabilities because if prior inspection, let's say if a prior inspection identified defects and the seller became aware, seller now has knowledge of this. And examples, foundation movement identified, or mold discovered, roof defects identified, a septic failure was discovered. The seller must evaluate and update disclosures accordingly. And keep in mind that disclosures must reflect the seller's current knowledge. Disclosure is not static, it doesn't just stay. Disclosure must reflect the seller's knowledge at the time of the sale, not months or years earlier. And this is what ends up happening a lot of times is a seller's disclosure. You put a house on the market in certain areas, that seller disclosure might be months and months old. Has anything changed from the time that they initially filled that seller's disclosure out to closer to maybe getting an offer? So we need to be sure that that disclosure truly reflects the seller's knowledge. And if it's outdated, it really needs to be updated. And then what happens when seller updates the disclosure? Well, updated disclosures protects the seller from lawsuits. It protects the agent and brokerage. It preserves trust that something has been updated. It stabilizes a transaction and reduces legal exposure. And it really just helps protect the transaction. And now some of you are probably sitting there saying, well, what if my seller refuses to disclose known material facts? Well, this creates a serious risk for both the seller and agent. As an agent, you have to understand that you cannot conceal any material facts that you find. So if you walk into a home and you see that there's a roof damage, you are required by law to disclose, even if your seller says you can't. You don't have the luxury of hiding material defects from the public. You can't provide false information as an agent. You cannot ignore known defects, and you cannot mislead buyers. And failure to properly disclose this information can lead to license violations. It can lead to civil liability, E&O claims, brokerage discipline. So it's interesting that in Michigan licensing law, you have an agent disclosure duty. And agents must disclose material facts known to them. And this obligation exists independently of the Seller's Disclosure Act. So you, as an agent, I'm just saying that you cannot ignore material defects once you're aware of them, and you have a responsibility. Now, selling your own property. Yes, Louis.
Yeah, question, Eric. Let's say seller asks the agent from the pending deal if the buyer emails any inspection report, says, I don't want to see it. And you are
Yeah.
directed not to receive it, not to send it. Are we as agents, if let's say involuntarily, the still buyer agent emails me, I'm a listing agent, emails me a inspection report, am I obligated to forward it to a seller? If let's say seller says, I don't want to see it, can I kind of ignore it for myself not to see it as well?
If you ignore it and don't provide it, you would be falling under a classification of potential misrepresentation or concealment.
Yeah,
It's a no-win
one of
situation.
one of the things we are bound by agency law is disclosure. We have to disclose any information we get to our seller. And to conceal that would be a violation of agency law, but also, as Eric says, an intent to conceal.
Yeah, that's kind of, I had a couple of times on broker support calls, so I just want to make sure our agents are aware of, of that. So
Yeah, and
that's good.
keep in mind that you are licensed real estate agents, so you are now held to a higher standard than a regular person of the general public.
Yeah,
Licensed agents are held definitely to a higher legal standard in the courts as well. So, you know, disclosing your license status, especially if you're selling your own property, let's say, as a licensed agent, disclosing your own license status, fully disclosing any known defects, avoiding misrepresentation, and providing accurate disclosure. In your condition that, let's say, you get an inspection report, or you could have easily said, hey, look, if you're gonna send over a repair notice, we don't want a copy of the inspection report, but you have to get that from your seller. You have to have that conversation with your seller. But again, it might be somewhere in the purchase agreement that a written notice will be provided along with a copy of an inspection report. We don't know. So we have to sometimes revert back to what the language is within that purchase agreement.
So
But
Eric, I'm sorry, I'm gonna ask, I just want to get a little clarification because I do the same thing, Luigi. I don't, when there's a situation where there's a repair coming in as a listing agent, I said, that's fine, send me the addendum, tell me what's going on. Send me the addendum of the repairs, but I don't necessarily want to see the report. I would definitely want to see the reports on the repairs though. Just for good compliance and for service to my seller, make sure it's proper. But I don't want to see the whole thing because that means I have to disclose it. So obviously, two scenarios. One, we go through repairs, everything goes great, that's done, right? But if it doesn't go great, I have to disclose the situation or like the knowledge, right? So do I have to disclose just the knowledge or like do I really need to get more information from the inspection report?
you don't need to prove an inspection report. You don't need to hire outside contractors to prove what's in that inspection report. This the danger is that the report that you end up getting, the inspection report, it ends up being newly acquired knowledge that could potentially be a situation in there that your seller may now need to disclose. But they don't need to go and try to prove everything in there
Mhm,
if they truly aren't aware
mhm.
of
Okay,
what's being said.
so always disclose regardless of, I mean, disclose the information found, but I don't need to go deeper into that, like to know more about other things in the inspection report.
They'd only be asking for what is being repaired, those sections.
Okay.
If you want to minimize risk, you would only want to see, if you're asking for repair, cite that portion of the inspection report. Now, agents aren't going to want to do that because that might take too much work. They're just going to send the whole thing. Just like, it'd be ideal if everyone did that, but no.
Yeah.
Well, I think one of the things we have to educate our clients about as listing agents is the process here when there are inspections done and there are defects found and what happens next. You know, if we get an inspection report that is credible, that they're going to probably have to revise their seller's disclosure form or provide different information than because now they have new information. So it's a conversation that really needs to happen at the listing appointment, not when the inspection comes back to you. See, Melissa had a question here. Melissa, can you ask your question here?
Don, so I was giving an example of something that actually happened. So a neighbor disclosed at a pre-listing meeting that they had a cracked well. And they didn't want to disclose this to sellers. And that broker who shared this story with me said, that's it. There was no way I could take that listing, that he didn't want to disclose it. And so along comes another broker. That broker takes the listing and the property sells for a nice price. Why would one broker decline and the other walk in and accept it knowingly?
Well, I think that one has scruples and the other one doesn't. I think it's a short answer.
They haven't had to pay the $50,000 check yet,
Yeah,
most likely.
yeah. I mean, part of it is it could be ignorance or shadiness or both. I mean, it's just, you know, that maybe they were ignorant to the fact that if they knew something that they were required by law to disclose it. But it's a very, very dangerous place to go. Lindy had a question there that I thought was a really good one. I'm trying to pull it up. Lindy? You there?
Yeah,
Okay. Your question, what if a seller's disclosure is incomplete? What is a buyer's agent's recourse? What is a seller's agent's obligation? And one of the, I'm going to answer that, but it kind of reminded me, we get the one from landlords and investors that says sellers never lived in the property. Eric, is that an adequate disclosure under Michigan law?
No, it's not.
Okay, good. Short answer.
We see it all the time.
Yeah.
right,
Sellers never lived in a property. I don't care, but you own it.
Yeah.
right.
How do you not know anything about an asset that you own?
Yeah.
It's just,
Yeah, it's ludicrous. That'll never hold up in court. A judge will do one of these. Yeah. And I've
So-
seen it happen.
So my question is, as a buyer's agent, can I go back to the listing agent and ask them to have the seller fill it out correctly?
Yes, you can. Will they? Don't know. The buyer does have the right to walk away. And the seller has, you know, I mean, I don't know what your recourse is if they are unwilling to do that. But I think the seller's agent's obligation is to disclose, as according to law, what they genuinely know about the property. If they know there's a problem, they need to disclose it. Melissa, your question about a trust. Great question. And it's a hard question because if it is a trust owned by the owner of the property, if the trustees are the actual owners who have lived in the property, then the answer would be absolutely they have to disclose. Okay. But let's talk about some exemptions. And when you start to talk about seller's disclosure law, there are multiple exemptions. Many of them have to do with bank takeovers, foreclosures, and conservatorships, and all of those kinds of things. If it is related to a court action, if the sale is going through because of a court action, then that particular seller is exempt from disclosing. Same thing with new construction. So, when you're going into transaction, you need to know what the nature of the disclosure requirements are.
Yeah, so really to kind of sum this up, we always want to make sure that the seller is aware of their obligation under the Seller's Disclosure Act and the dangers of what happens when they don't properly disclose all of their facts. In the court cases that we see, or what's being cited, I should say, by the attorney is always misrepresentation, silent fraud, concealment, and then they slap on the civil liabilities. And then my head just explodes. And I'm like, wow, they really like to put down as many things as they can from a legal standpoint. So the seller should really be as thorough as they can, put every little thing in there that they can, and understand that inspection reports create knowledge once a seller becomes aware.
I
So
have a question.
if you don't
Oh,
want the inspection report, say no.
I have a question, if I can interrupt.
Sure.
Don had mentioned that you need to update the seller's disclosure. If you're in the middle of a transaction and you're negotiating with the buyer, do you still have to update the disclosure then? Because they're already aware of it. Is it only if it goes back on the market that you have to update the disclosure, or at what point do you do that? Do you understand what I'm asking?
Yes. So here's what happens real life. It never gets updated, right? What should be done is that if there's a new defect, the seller should be updating their seller's disclosure once it becomes aware. Do we practice that in real life? No. Do we get sued because it didn't get updated? All the time. So the mindset is that anytime something happens that's new that the seller is now aware of, that fits within the scope of the seller's disclosure, should really be updated and disclosed.
Yeah, in fact, our purchase agreements actually ask for that information, that the property condition is the same as when the property was listed, when the offer was written. And I think that would hold as a practice that would be required, that if you find some material defect as a result of inspections or something else, you have to disclose it. Now, I want to go back to Melissa's got a couple of questions here, and I want to follow up on these. Your example, Melissa, was about a trust. And again, we're into a gray area because family members are inheriting the property that was now in trust. And I'm not sure how that all worked, if it was in trust prior to the seller being deceased, or if it moved into a trust or an estate after that. It's a fine point, but one that may matter. And the reason, again, I'm going to give you this example. It's true. Wow, this is really weird that my current sale is going through all this stuff. In this current sale, the property had been transferred to the children prior to the parents' death. It was not a trust. It was not an estate. It was actually set up because we knew mom was passing, and their attorney recommended that it be put in the name of all four children, or all the mom and the three children. So because of that, they are required to, even though it's kind of an estate property, they were required to disclose. They were not exempt. Now, a trust might be considered exempt if it was happened as a result of an estate. I'm not sure how that property would have moved after death into an estate, but now you're getting into some legal weeds that are pretty tricky to navigate. And if you run into that with a specific information situation, give us a call. We'll do a deep dive on it and work you through it, okay?
All right, any other questions?
Jason has his hand raised. Go ahead, Jason.
I just have a question regarding how far back you need to go with disclosing. For example, if you have a seller, let's say that's
Forever,
only lived in their
Forever.
home forever. So like, is it a responsibility of our,
100
if we're a
years.
listing agent, if we're a listing agent, do we need to look back at previous disclosure statements and provide them for our seller?
The courts would say, go ahead, Don.
Well, only if you don't have to go in and dig through seller's disclosure forms that were previously filled out unless that homeowner saw those previous disclosure forms when they bought the property. In that case, the answer would be yes.
So if they, let's say they've only lived in their home for 2 years, they obviously, when they bought the home, they signed a disclosure statement. Is that seller responsible for translating what was on that disclosure statement to what they're filling out?
Yes.
And is it our job as a listing agent to ensure that that happens?
I like to answer this one because we've seen a court case
Okay.
on it. So
I'm just wondering, as a listing agent, do I look up am I going back and looking at past sales and pulling up disclosure statements? And then when I'm doing the listing paperwork with my seller, am I actually furnishing this information or is that going too far?
as a listing agent, I would definitely be pulling up the previous time when the home sold, at least one time back. It could even be more. Typically, if you're going to a listing, you might look back anytime it was listed in the past, looking at the seller's disclosure, and then having a question for your seller about, hey, I noticed in the past 20 years ago, there was some type of water. Are you aware of this? And it could be simply that a past previous seller's disclosure indicated that there was water at one point. They might be able to say that I've had no issues. At least if you're disclosing it, you can never come back. No one's going to come back on you and say that you weren't honest about what you truly knew.
And the same, I mean, you can kind of flip this to the buy side too. If you're representing a buyer and you're looking at a disclosure statement, you pull up the previous sale and there was water in the basement and there isn't on the current. I mean, this is also something to keep in mind for the buy side, correct?
For the buy side, now you have a red flag that you're going to really want to explore a little bit deeper into an inspection to satisfy your needs of the home.
Can anyone see previous disclosures? Like, I can't go back and look at disclosures when a house sold 4 years ago. I can see the listing ticket, which gives me an indication of the flowery words that might indicate a roof or a furnace, the age of it. But I think as a listing agent, if you help the person buy the home, you should provide them with a copy of the seller disclosure statement as a baseline for their beginning as they look at what was previously known and now what do I know? Because I have now lived in the home, I have made repairs, I'm aware of defects. So think of sharing that previous disclosure that you had as sort of a starting base.
Isn't disclosure fun? It just goes to realize that it's a much larger conversation that we never have with the client. It is a really truly complex situation in a real estate transaction that if done incorrectly, it's an easy target for an attorney to sue you over, in my opinion.
Yeah, I got to listen to this, please.
Any other questions?
For me, one more thing for just a comment. I know for us as a listing agent and a seller, it can be uncomfortable to encourage them to disclose everything, good, bad, and ugly. I mean, the ugly, not the good. But if we explain it properly, the potential damage and a lawsuit that can come and bite them even 10 years after the closing, perhaps, I think they will be then okay to disclose because I always tell the seller, we only need one buyer that not gonna care much about whatever disclosure you put in. They're gonna do their investigation. They're gonna be okay. You know, they can never come after you if you disclose it. And we only need one buyer who will look past that. So it's really, it's like, I agree with Eric and Don and everyone, just to take extra time to encourage our seller to disclose everything.
And here's the great thing about having everything disclosed up front is that can really put the seller's mind at ease if they disclose things properly. Because if there is a lawsuit, you know, there's nothing stronger than being able to say, hey, look, I filled this out to the best of my knowledge and everything I had there. I'm sorry that when you bought this home, all of a sudden an issue happened. But it gives them a better place to stand their ground if they've been honest. And also, you've built a relationship. If you're disclosing, well, okay, let me skip thoughts here. I hear typically from a lot of sellers, well, I don't want to list all these issues because now my house might not get I might not get a higher price for it because there are all these past issues. Well, the other side is, hey, all these past issues were actually corrected and fixed by the seller. This person is actually on top of things. And if there's no more issues, then yes, they should get a higher price for it. And it leads to honesty and truth. And it's going to be a good outcome for both agents. Hopefully, if the agents don't cause issues between each other, right? If they play nice in the sandbox. But it's a good feeling for a seller to actually disclose everything and minimize any risk of being sued later.
And
That's all I
Lindy
have.
has a question. Lindy has a question on chat. So if the seller doesn't completely or correctly fill out the disclosure, can or should not a listing agent point that out to the seller and ask/tell them to fill out correctly?
Yes. So here's where it comes down to. If you as an agent are aware of a material defect, you can't hide that fact. We would highly encourage the seller to update their seller's disclosure based on what they know. Now, if they're telling you that I'm not going to disclose that, now we have a problem because you're required to disclose that to any potential buyer, and that should be notified to the seller. The other potential issue is that you might not want to represent that client, and you may have to break your relationship.
I think Lindsay's advice here is excellent. Picture yourself in front of a judge. Judges have heard it all before. They know when they're hearing nonsense. And so when you're standing in front of the judge trying to say, well, I didn't realize that the basement had water and you know, there's water in the, you know, the carpeting is soaked. The judge, and I've had this happen, the judge looked over his glasses and said, as a homeowner, you should have, and found for the buyer. So Melissa had this comment, what are there situations where it's helpful to have a detailed inspection beforehand? And the answer is, you're not required to do that. As Eric said, you don't have to go digging around, you know, to find things that are wrong with the property. However, if your seller feels as though that's something that they want to do, by all means, I encourage them to do it. I think it can be a sales tool, a good selling tool for a buyer to feel as though the property that they're making an offer on, that they know what they're buying. I don't think it's a bad practice at all. It's not required, though. Would you agree, Eric?
Yeah, I think it'd be a great tool if there were concerns that a seller might have. They want to do pre-inspections on the home and then be able to say, hey, this house is clean. There's a question about a flipper who doesn't fill out a seller's disclosure properly. What should the buyer do? Well, a lot of times when you, as a buyer agent, and you go and looking at homes, you might already see that the disclosure is half filled out by the flipper, you may want to have some type of language within the purchase agreement in your offer that says that this offer is contingent upon buyer's review of an updated seller's disclosure to be provided by the seller on or before blank date, and then the buyer will have 3 days to review. You could put some type of language in there to protect yourself, especially if you have a questionable flipper who is doing a lot of unknowns or not truly telling the truth completely.
Yeah, I think that's excellent language, Eric, and maybe we can share that with agents on Facebook Connect or something. In addition to that, I would encourage when you get that sort of disclosure that says, it's an investment property, sellers never lived in the property, scrawled across the page. I think we've all seen them. You can identify specific questions that your buyer might have. This offer is subject to sellers disclosing information about electrical, plumbing, heating, whatever you might have. You can go back and be very specific about your buyer's major concerns.
Did we get everyone's questions? If anyone else have a question, we'll be happy to answer it. Or tell you what we feel. We don't know if it's correct, but we'll do our best. Well, if you do have further questions, reach out to the broker support. You can always give us a call, or you can email any of us, and we'll be happy to respond back to you. But thank you for your time. We appreciate it. We're here for you. So again, thanks for your time this morning. Thanks for listening to me and Don and to Tracy and to Louise and Doug and everyone else in our broker support. Have a great day.
Thank you,
Hey,
guys.
Eric,
Thank you guys very much.
Eric,
Yes, go ahead.
would you be willing to stay on after everyone? Doug,
Sure,
would you
I'm
stay
ready.
on too?
This is the extra 15-minute bonus clip. Only here